What is grievance arbitration? Grievance arbitration is a method of resolving disputes between employees and employers under a collective bargaining agreement, CBA, where a neutral third party, the arbitrator, hears the case and issues a binding decision. In simple terms, it is a private legal process used in unionized workplaces to settle disagreements, such as discipline, discharge, or interpretation of contract terms, without going to court or resorting to strikes. The origins of grievance arbitration in the United States are tied to the growth of organized labor in the early and mid-20th century. As unions gained recognition under the major National Labor Relations Act of 1935, collective bargaining agreements became the backbone of labor management relations. These agreements not only set wages and hours, but also established grievance procedures to handle disputes. Arbitration emerged as the final step in those procedures, providing a peaceful alternative to industrial conflict. After World War II, grievance arbitration became a standard feature of American labor contracts, supported by both unions and employers as a way to ensure stability and fairness. The typical grievance process unfolds in stages. Filing a grievance. An employee or union believes the employer violated the CBA, perhaps by disciplining an employee without just cause, misapplying seniority rules, or failing to provide promised benefits. The grievance is filed formally, usually in writing. Step meetings. The grievance proceeds through several steps of discussion, often starting with the supervisor and moving up to higher levels of management. At each stage, union representatives advocate for the employee, and the employer has an opportunity to respond. Arbitration. If the grievance is not resolved internally, it proceeds to arbitration. A neutral arbitrator, chosen by agreement of the union and employer, often from a panel provided by agencies like the American Arbitration Association. Association conducts a hearing similar to a trial. Witnesses testify, documents are presented, and both sides make arguments. The arbitrator then issues a written decision, which is usually final and binding on both parties. The scope of grievance arbitration is broad, but it is rooted in the language of the CBA. Common issues include discipline and discharge, overtime disputes, job assignments, health and safety concerns, and interpretations of contract clauses. For example, if an employer fires a worker for absenteeism and the union argues that the dismissal lacked just cause under the CBA, the case may go to arbitration. The arbitrator will consider evidence such as attendance records, past practice, and fairness, and then decide whether the employer violated the contract. A landmark Supreme Court case, United Steelworkers v. Warrior and Gulf Navigation Company, 1960, emphasized the centrality of arbitration in labor law. The court declared that arbitration is the preferred method of resolving labor disputes, reflecting a national policy favoring peaceful settlement over strikes or litigation. Later cases reinforced the idea that courts should defer heavily to arbitrators' decisions, reviewing them only in rare circumstances, such as fraud or misconduct. The advantages of grievance arbitration include speed, expertise, and reduced conflict. Arbitrators are often specialists in labor relations, able to interpret complex contracts and workplace practices more effectively than generalist judges. Arbitration is also less formal and more efficient than litigation, allowing disputes to be resolved relatively quickly. Importantly, it provides a sense of fairness and due process for employees, while giving employers predictable rules and avoiding disruption of operations. A curiosity about grievance arbitration is its cultural role in unionized workplaces. Over time, it has become not just a legal process, but also a ritual of industrial democracy. Workers gain confidence that their voices can be heard, while employers benefit from stability and fewer strikes. In many industries, such as steel, auto, and public employment, grievance arbitration is so entrenched that it is considered the common law of the workplace. In conclusion, grievance arbitration is the mechanism by which disputes under a collective bargaining agreement are resolved fairly and peacefully. By channeling grievances through structured procedures and neutral arbitration, it balances the rights of employees, the authority of employers, and the collective strength of unions. Rooted in the history of American labor law and upheld by landmark court decisions, It remains one of the most important tools for ensuring justice and stability in the modern workplace. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.